Hello everyone, welcome back once again to your favorite channel, that is StudyIQ English. I am your educator Praveen Mishra and we are going to discuss today's burning topic. It's about Shreya Singhal versus Union of India case. Okay, freedom of speech and expression in question again, as we have discussed into the Kunal Kamra case, right? So what is the background of the case? In November 2012, when India lost one of its very famous and very powerful leader as well, that is Bala Saheb Thackeray. At the eve of his death, there were two girls from the state of Maharashtra, those who posted something over their Facebook profile. Well, we don't exactly know what was actually the post, but against that particular post, those two girls, they were arrested and they were prosecuted, okay, on the charges of defamation. So 3 years later, Shreya Singhal, she filed a petition in respect of that particular case, okay, defending those two girls, whether they are to be said innocent or not, okay. So this is exactly the case. What is this? Once again, in November 2012, we lost Bala Saheb Thackeray, and after his death, there were two girls basically, those who posted something. What is the post? Exactly, we don't know, okay. That is basically, as per the events we can understand, it was something against Thackeray only, right? Hence, as a result, these two girls, they were arrested and they were prosecuted on the grounds of defamation. So, in defense of these two girls, once again, Shreya Singhal, she filed a petition considering Section 66 capital A of the Information Technology Act, okay? So, once again, right? Shreya Singhal versus Union of India 2015, landmark judgment by the Supreme Court of India that struck down Section 66 capital A of the Information Technology Act of 2000 as the unconstitutional thing, right? So what Supreme Court stated, it is literally unconstitutional. So what is the case once again? What is Section 66 capital A first of all? Okay, how do we define this thing? Okay, that is Section 66 capital A now. So of the Information Technology Act 2000, it made, okay, it is a punishable offense for any person to send offensive information using computer or any other electronic device. So as per 66 capital A of the Information Technology Act, any person who shares any offensive information using a computer or any other electronic device, it will be considered as an offense, right? So the provision also made it punishable for a person who sent information that they believe to be false. Remember, believe to be false, not yet proven to be false, right? Section 66A had prescribed 3 years of imprisonment if a social media message caused annoyance or was found grossly offensive. Okay, what? If any particular message is found to be, spreading annoyance or to be grossly offensive, then the person who has shared the message could be imprisoned for up to 3 years as per the Section 66 capital A of the Information Technology Act of 2000. Now, even sending emails for causing annoyance, not just the messages, even the emails, okay, that causes annoyance or inconvenience or to deceive or mislead the recipient about the origin of the message was considered as a punishable offense under this section. So, yes, this was the particular event. And now against which? The background, okay? Criminalizing sending offensive, okay, so it was challenged after two girls in Maharashtra were arrested in 2012 over a Facebook post for criticizing the shutdown of Mumbai after Bala Thackre's or Bal Saheb Thackre's death. What is exactly the post? Okay, it's a matter of, type of a, what we can say, mystery or something like that. So, Shreya Singhal, a law student, she filed a petition, that is a PIL, that is simply speaking, okay, public interest litigation, questioning the vagueness and arbitrariness of the provision. So, this is what simply the Shreya Singhal case is, okay. And now the next thing, the key issues. What was the challenge into the case? So, it was once again Article 19, Clause 1, Subclause A. So did Section 66 capital A infringe upon the fundamental right to freedom of speech and expression? So what Supreme Court stated, yes, it did, right? So reasonableness was the concern, So reasonable restrictions we have got. As per the doctrine of reasonable restrictions, fundamental rights are not absolute. They are not sacrosanct. They are not divine. They can be suspended during emergency, during martial law, or maybe other exceptions could also exist. And yes, fundamental rights, they do come with the reasonable restrictions as per their own provisions. Okay, considering the dignity of an individual, the defense of the country, the internal security, the harmony, the social fabric of the nation, we can consider all of these things as reasonable restrictions to the fundamental rights, right? So yes, this is also mentioned under Article 19, Clause 2. Okay, so could it be justified under the reasonable restrictions clause? That is section 66 capital A. That is, any message that has been shared between two people. Okay, and now you are prosecuting those two people that they are spreading annoyance or type of deception or misleading thing. Now, vagueness of the law. Terms like grossly offensive and menacing were not clearly defined. That led to the misuse of the law as per the Supreme Court's issue, right? As per the Supreme Court's judgment. Now, the next thing, what exactly Supreme Court stated? So, as we can see here, the Supreme Court struck down the section 66 capital A as violation of Article 19 Clause 1 subclause A and not saved by Article 19 Clause 2. That is, it is not a reasonable restriction. Conversation between two people. It's their private thing, it's their private matter. We as a state cannot intervene there. Then, held that vague and overbroad expressions led to the chilling effect on free speech. And now what is this chilling effect? Chilling effect is a type of a threat or a type of the fear that an individual might possess, that if he or she posts anything over the social media, then that individual could be prosecuted. Okay, so this particular threat or this particular fear that is inscribed into the minds of the people, this is what as per the legal terms termed as the chilling effect, right? So as per the Kunal Kamra case, okay, that fact checker unit was also a chilling effect, and now section 66 capital A was also a chilling effect. That is providing unnecessary threat or a fear into the minds of the common masses is something which is absolutely against the principles of democracy. And yes, it was also violating Article 19 Clause 1 subclause A, that is freedom of speech and expression, and their Supreme Court stated that though reasonable restrictions are mentioned under Article 19 Clause 2, but this particular section 66 capital A doesn't justify those reasonable restrictions, right? And hence it was declared as what? Literally unconstitutional. So the court emphasized that free speech on the internet deserves equal protection as other forms of speech they do, right? So this is what the Shreya Singhal's case judgment is. And now here once again the chilling effect, what does it refers to? It refers to the discouragement or suppression of legitimate expression due to the fear of legal sanctions or punishments. Okay, everyone. So this is it all with regard to the Shreya Singhal case that struck down section 66 capital A of the Information Technology Act as being violative of Article 19 Clause 1 subclause A, and it didn't got any protection under Article 19 Clause 2. Okay, everyone. Thank you so much for watching this short session, and please remember you need to subscribe to the StudyIQ ICE English channel so that you never miss any update from the channel. And apart from that, if you wish to connect with me, so we can connect over two platforms, as you can see. On Instagram, you can search me with the username Praveen Mishra _2107, and on Telegram you can join my channel, that is a study_with_Praveen. So wherever you are comfortable, you can connect with me and let me know what are your doubts and how I can help you in that. Okay, and I assure you I shall get back to you at the earliest possible time. Okay, everyone, thank you so much for watching again. Good day, take care, bye bye, Jai Hind, Jai Bharat.